case where the media has not been invited to all the proceedings. The media is well aware of the proceedings. The media is here today. Special considerations have been made for the media. The court has an order regarding the media. So the media, and particularly in light of the Maine State Media's appeal to the law court, they're now invited to jury selection. So they're invited to jury selection. They're invited to every proceeding. And everything's part of the public record. So to the extent that the public needs to be informed about this case, they are informed about this case. They're continuing to be informed about this case by TV, by newspapers. So this isn't a case that's being held in secret, and certainly a public who wishes to be informed can read the paper, can look at the news, and form their own conclusions. Furthermore, it doesn't require counsel for the state or the defense to talk to the media in order to explain what the proceedings are.
All of the speculation, innuendo, and rumors and anonymous phone calls bury my client in adverse publicity and have ever since. So, you know, the color was already made and painted by the state, by the police officers, and somewhat by the prosecutors. And so, it's not a question of what's necessary, what's not necessary. The press's rights are protected. They're here, they won their case, and they're here to hear the rest of our one-year examinations. And the law court has said that that's important. That a public trial is important and discussions be had. According to the reported notice, that kind of discussion during the event is important. That's why you have public trials. Everybody can watch and talk. And that doesn't exclude us. And finally, let me just re-emphasize on paragraph 8 of our memorandum, in which we think the Fifth Circuit or Sixth Circuit put it pretty well. It said that while the government shares an interest in a fair trial, a right guaranteed by both the federal and Maine constitutions, is granted to all criminal defendants, not to the government. And it says, quote, in the Fifth Circuit case that we cited, the United States versus Ford page, on paragraph 8, Sixth Circuit case, quote, to the extent that publicity is a disadvantage for the government must tolerate it. The government is our servant, not our master, end of quote.
Thank you.
In the bar rule, it talks about the interest in the public. I agree with that. And in the comment under 3.6, it says, furthermore, the subject matter of legal proceedings is often of direct significance in debate and deliberation over questions of public policy. I think that's particularly pertinent to the cases that bring us here. But my imposition of the order was not proactive, it was reactive to the statements that I heard about and were told were in the press. And I think that, as I said, they were not helpful to the process, they were demeaning to the state, and I am not willing to take the chance that additional statements would be made prior to seating the jury. And if that can happen by tomorrow, I think that would be best for everybody here. So I'm going to ask that order, with regard to counsel for Mr. Strong, continue. I do not have any reason to believe that Mr. Strong has made any comments, and I hope that he would not, between now and the seating of the jury, become a conduit for any statements that I would consider inappropriate. So the order is going to remain in place to defense counsel and the state's counsel until the jury is seated. Right. With regard to that, I have decided that we should ask the jurors, and this will be the message tonight, to come tomorrow. We will try to finish the voir dire for the original jurors. Obviously, there are going to be questions that need to be asked of the jurors who have already been questioned. And if we can succeed in choosing a jury, we can begin the trial tomorrow.